Imagine this. A regional bank deploys a new payment processing system. The code was written by an AI in plain English. A developer typed a request, accepted what came back, ran the tests, shipped it. 3 weeks later, customers start noticing transactions they never authorized. Money moving between accounts that don't belong to them. The bank shuts the system down within hours, but by then, thousands of customers are affected. Total losses run into the tens of millions. The lawsuits get filed almost immediately. And here's the question that nobody in that courtroom is going to have a clean answer to. Who actually wrote the code that broke? That's the scenario our MEIA analysis flags as the liability cascade. And we put the probability of significant fracture at somewhere between 40 and 60% within the next several years. That's a wide range, and we'll explain why in a minute. But the core finding is this. The legal framework that governs commercial software is built on an assumption that's about to stop being true. The assumption is that a human wrote the code. And the same vibe coding boom that's straining power grids and breaking insurance markets is about to do the same thing to the entire body of software liability law. That matters for a reason we'll come back to at the end of this episode. Because if the legal system can't assign responsibility, the next thing that breaks is the workforce that used to carry it. Let me explain what this actually means in practice. For the last 40 years, software liability has rested on 3 legal doctrines that all share a common structure. The first is product liability. If a company sells you defective software and it harms you, the manufacturer is responsible. The second is negligence. If a developer fails to exercise reasonable care and that failure causes harm, you can sue them. The third is contractual warranty. When a vendor sells software, they implicitly or explicitly warrant that it will perform as described. Now, I want to be precise about one thing here, because the legal framing is genuinely complicated. Software has always sat in an awkward place in product liability law. Under the Uniform Commercial Code in the US, a lot of software is technically treated as a licensed service rather than a product, which has historically given vendors more protection than, say, a car manufacturer would have. So when we say AI is breaking product liability, what we mean more precisely is this. Courts are now openly debating whether the weights of an AI model constitute a product, even if the code those weights produce does not. That distinction sounds technical, but it's the entire ballgame. If model weights are a product, AI labs can be sued like manufacturers. If they're a service, they can't. Nobody has a definitive answer yet, and the answer is going to determine billions of dollars in legal exposure. But here's the part where it gets really hard. Even if we sort out the product question, the deeper problem remains. AI-generated code breaks all 3 doctrines at the same time because every traditional defendant has a clean answer for why it wasn't them. The company that deployed the code didn't manufacture the defect. They prompted an AI in plain English and accepted what came back. The AI lab didn't deploy the code. They built a general-purpose tool. The developer who used the AI didn't write the code either. They typed a sentence and clicked accept. Every link in the chain points to the next link. And the AI itself is not a legal person. It can't be sued. It can't be held to a duty of care. It has no assets. The chain of responsibility just dissolves. There is one legal theory that's quietly moving from the academic margins toward mainstream practice, and we think it's going to matter more than people realize. It's called negligent entrustment. The idea is straightforward. You're not liable for the harm the tool caused. You're liable for the decision to use the tool without adequate supervision. It's the same theory that holds a parent responsible if they hand a loaded gun to a child. Applied to AI, it would mean a company isn't liable for the hallucinated code itself. They're liable for choosing to deploy AI-generated code without a qualified human verifying the output. We think that's where a lot of jurisdictions are going to land, because it preserves accountability without requiring courts to make an impossible decision about who wrote the code. But not all jurisdictions are going to go that direction, and this is where the second-order consequences kick in. Different courts and different legislatures are going to make incompatible choices. The European Union, through the AI Act, is already moving toward a strict liability framework for what it classifies as high-risk AI systems. Anything in healthcare, critical infrastructure, finance, hiring. Meanwhile, emerging tech hubs like Singapore and Dubai are signaling a much more permissive posture, treating AI output more like search engine results, where the user is fully responsible. Within 5 to 8 years, our analysis expects you'll see major jurisdictions taking fundamentally incompatible positions. And that creates a problem for any company operating across borders, because the legal posture you have to take in Frankfurt is functionally incompatible with the one you have to take in Dubai. International tax lawyers already have a name for what happens next. They call it forum shopping. Companies choosing where to incorporate, where to host their infrastructure, and where to sell their software based entirely on which liability regime gives them the cleanest legal exposure. We saw the early version of this play out with GDPR fragmentation. AI liability is going to make GDPR look mild. The first big lawsuit is going to be the moment everything changes. We don't know exactly when or where, but the structural conditions are already in place. Some company is going to deploy AI-generated code, something significant is going to fail, and the plaintiff's lawyers are going to name an AI lab as a co-defendant. Not because they expect to win on the first try, but because the case will force courts to actually answer the question. Whatever answer the first major court gives, it sets the pattern for everything that follows. Here's the strategic angle that nobody's really talking about. The jurisdictions that solve attribution first are going to gain a significant competitive advantage. If a country builds a clear, coherent legal framework for AI liability, one that companies can actually plan around, that country becomes attractive for AI development and deployment. The jurisdictions that delay, or that try to apply existing law to a fundamentally different problem, are going to push innovation elsewhere. This is one of the few places in the entire MEIA analysis where being early is genuinely better than being right. There's a version of this story that ends well, by the way. It's not the most likely version, but it's worth considering. A breakthrough in formal verification, the mathematical proof that code does what it's supposed to do, would partially solve the attribution problem. If you could prove that a piece of AI-generated code was verified before deployment, you could plausibly hold whoever skipped the verification accountable. Our analysis puts this at somewhere between 3 and 8% probability over the next several years. Low, but not zero. And if it happens, it changes everything we just talked about. The deeper question underneath all of this is one we keep coming back to in this series. Legal systems are built on the assumption that humans make decisions and that those decisions can be examined, contested, and assigned responsibility. AI-generated code doesn't fit that model. It produces decisions without a decider. It creates artifacts without an author. The courts, the insurers, the regulators, they're all about to discover that the categories they've been using for 40 years don't have anywhere to put this. And remember the bridge we set up at the beginning. This isn't just an abstract legal problem. When the liability question can't be answered, the people who used to carry that responsibility, the engineers, the maintainers, the institutional knowledge holders, they start to walk away. Not because they've been replaced, but because the entire structure of accountability they were trained inside of no longer exists. That's the next failure in this cascade, and it's the one we think about most. Next time, we look at the workforce collapse, the junior developer pipeline breakdown, and what happens when an entire generation of software talent quietly steps out of the room.